For pronouncement of judgment, item 28 and 29.
In view of the discussions made herein above, we find no information in the judgment and order dated 25/2019 of the learned single judge. So far, it relates to the rejection of the prayer of appellants for direction to the government of Assam for payment of salaries and allowances to the appellants. However, the conclusion of the learned single judge holding the ASU an authority under Article 12 of the Constitution of India is interfered with, accordingly stands reversed. And the result, both the writ appeals are dismissed.
Yes, Worship, item number 1, 2, and 3. Actually, I missed the matter. Worship. Maybe I missed the matter. Worship.
You have missed the matter.
Yes, Worship.
Okay.
May I take the after vacation? Worship.
Here submits that he could not mark the files as his name was not mentioned in the call list. He placed for a short accommodation list after ensuing puja vacation.
My lord, may I request for a date, my lord? 14th December, my lord.
14 December. Then simply mention list on 14 December as paid. Don't know that puja vacation. Yes.
Lordship, item number 13, madam. It's a contempt matter, my lord. We have filed an affidavit yesterday, madam, indicating compliance, my lord. But she also has copies been served to her also, madam.
What do you want?
Kindly fix the matter after vacation, Lordship.
Mr. So Gogoi submits that he has filed affidavit regarding compliance of the order under contempt. The same be brought on record. Counsel for the petitioner pays for time to complete her instructions. List after ensuing puja vacation.
Wait, Lordship, in item 25, pleadings are complete, my lord. We filed the affidavit recently. So can it be taken after the vacation, my lord?
As paid by Mr. Senior Counsel, Mr. So and so. List after ensuing puja vacation.
My lord, may I pray listing the matter tomorrow? We have filed on yesterday, my lord.
What is the appeal about, sir?
My lord, regarding medical admission, my lord.
All that get it listed tomorrow.
My lord.
May I please, Lord? Lordship, I beg to mention an item for listing, Lordship. This is a writ appeal, Lordship, regarding appointment in a college, Lordship. So, Lordship, the appellant's appointment has been interfered by the order of a honorable single judge, Lordship.
What is the date of the impugned order?
Lordship, 8/9/2023, Lordship.
It's almost more than a month.
Yes, Lordship.
So why you are waking up at the last moment?
Lordship,
More than one and a half months. So what happened in the meantime? Let it come up after puja vacation.
Lordship, actually, if
there is no extreme urgency, gentlemen.
Lordship, urgency is if that order is being implemented, Lordship.
So it's 1.5 months. If you are sleeping for 1.5 months, 8th September. Today we are on 17th October. 1.5 months, almost. When did you file the appeal?
Seek apology for that.
When did you file the appeal?
Lordship, that was filed on 4/10/2023, Lordship.
All right, get it listed tomorrow. Let's see.
Highly applies, Lordship.
May please, your lordship. My lord, I pay for listing of a day after tomorrow, my lord. Here a candidate is a applicant is a my lord candidate of BDS course, my lord, because of the order passed in the retable, my lord, her admission was cancelled.
All right. Day after tomorrow.
May I please, your lordship, first I get to mention item number 26 on
Yes.
behalf of N. Ahmed. Lordship, may kindly adjourn the matter.
All right, a request is made to adjourn the matter on behalf of Mr. M. Ahmed, advocate representing the appellant. List of claims to the relation.
Next.
Daily list forwarders, item 6.
May it please, your lordship. Look, this is with regard to the construction of the road in the Malibagan area in the High Court.
What has happened?
11/10/2023 note, my lord, will have a look. Now the soil testing, because the boundary wall will be in a hilly terrain, so they wanted some time. My friend has informed that soil testing has already been.
Soil testing has been done on Friday last month.
Mr. Nath submits
Now
that
we are
the
waiting for the.
executive engineer at PWRD Guwahati has initiated the process of subsoil investigation so as to find the engineering properties of the soil, which data would be used for structural design of the retention wall. The PWDR has paid time till 28/10/23 for doing the needful. Re-notify on 9th November.
My lord. Deeply.
The latest status report be placed on record on that day.
Yes, ma'am.
Item number 7 to 11.
Well, in 7 to 11, my lord, I pray for some time, my lord, let it be after vacation, my lord, some additional affidavit is to be put on record. My lord.
What are the matters? 2018 appeals.
18,
Mr.
The subsequent development, otherwise, my lord, they have come for hearing.
They have come for.
Earlier it was in the hearing column, my lord. Subsequent developments are there. That is
Okay.
why, my lord, we want to brought it on record. My lord.
Yes, yes, yes. Otherwise, what you were saying, what new developments are you trying to bring on record?
Well, in fact, in respect of the this,
What is the controversy? Tell us first.
well, we have taken a decision for appointment of contractor, transport contractor
Okay,
for transportation of PDS items from for FCI godown to the GPSS godown and from GPSS godown to the FPS shop. They are opposing that appointment of that policy. Engagement of transport.
okay,
contractor.
okay. Mr. Nath, senior standing counsel, Mr. Nath, senior comment advocate, Mr. Nath. Submits that fresh affidavits are required to be filed on behalf of the state in view of the new developments which have taken place during pendency of these appeals. He prays for and is granted 3 weeks time to do the needful. Affidavit on behalf of Union of India has also not been filed, have also not been filed. Needful be done in the intervening period. List after 3 weeks.
Much of.
Item number 12.
Around 6:10, my lord, our impleadment application, my lord, for impleadment response of 5.
Yes.
We've accordingly deposited, my lord, the cost title. my lord.
Cost title is filed. The cost title has been filed. Now what's to be done? What is the PIL about?
Well, it's about, my lord, transfer of 5, my lord, villages of, my lord, Kasha district, my lord, to
Now-
Malibagan district, my lord.
Okay,
Now, my lord, perhaps the name of the, my lord, ECI, my lord, election commission standing council is reflected, my lord. It's not there, my lord.
okay. Ms. Saikia, you file your affidavit?
In fact,
State has filed, my lord.
state has filed, we have filed.
So let name of standing counsel for Election Commission of India, the newly implemented respondent be reflected in the cause list and the matter be re-notified thereafter.
We'll serve copies on them.
Copies of the petition be provided to learned standing counsel. The appearance of learned advocate general Assam shall also be henceforth shown in the cause list.
Highly obliged.
Item number 14.
What is I about?
About readable
What is the IA, sir?
for condemnation of delay of 68 days. That's it.
You are for the respondent number 5?
Yes, my lord.
Do you oppose?
I am appearing for the respondent number 5. I have no objection, sir.
No objection. Okay. Delay 68 days, no objection. I allowed delay unknown. Connected rate appeal be numbered and listed for admission.
Item number 15.
What is this about, Mr.
This is
Shogoi?
about the compassion appointment matter. Applicant is agreed by order passed by a single judge when rejecting his claim for compassion appointment. Date is of 2010. Rejected on 2014. He comes to court in 2023.
Hmm.
He's not there, madam.
We had asked him to file the application on record.
My lord, yes. Also, my lord had also indicated that he has to satisfy who are his dependents, his economic strength. But he
Yes.
has merely annexed, my lord, only that form.
That's all.
That's all. madam.
No, he has given out the list. Wife, son.
That is there, madam. Wife's son is there.
Son is this,
Yes.
what is the name? Krishna Parole. His dependents. Other than the mother, there is no one else.
We don't.
The other are all adult members. And then one more thing, Ms. Gogoi,
My lord.
we want to know that where there are other claimants, whether the application can be entertained without their no objection. What is the criterion? Merely by being the eldest offspring, whether that gives a right,
No, my lord.
then
My lord, only one can apply, my lord.
one, but who would that be?
Direct
there-
descendant, my lord. Son,
Direct descendant, there are 2 sons and 2 daughters.
There has to be no objection, my lords.
That's not there even. Pasur.
My lords. That element of compassion is also not there, my lords.
Is there any indication in your guidelines that if there are more than one offsprings, what would be the criterion?
That I have to look into, madam. That I have to look into. I'm
Okay.
not very aware.
All right, none present when the matter was called out. List after puja vacation.
People aware.
Item number 16.
My lord, in terms of my lord's last order, affidavit has been filed by the state, basically reiterating what was there in the preliminary affidavit. With the additional thing, my lord, that till date, the select list was not cancelled.
Yes, on records, my lord, they have verified. It has not been cancelled.
Then
Probably, my lord, in the meantime, the repetition was filed. That's why, my lord, no decision otherwise on writing was taken.
as on date, they are in service candidates.
No, my lord, so far as the select list is concerned, my lord, they were
Yes.
not appointed, my lord. Only the select list was.
Also, select list is live. Select list is never cancelled. Why appointment orders were not issued? If that is a question.
Lordship.
In fact, my lord, during the pendency of the writ petition, keeping this, my lord, 22 posts, 47 was again advertised.
We know that.
Yeah.
We know that. Yes. So
Probably,
now
my
what is your stand now?
lord, otherwise, my lord, the department feels that, my lord, that.
You have
Yes.
appointed other people on the same criterion.
that
So how
was
can you
COVID
discriminate?
Pandemic time, my lord, that was done. By that time. my
Whatever.
lord,
You have not said
my
so
lord, yes.
that their appointments are illegal because they were done in the pandemic time. You have vacancies. Your office or your hospitals are short staffed every moment. There is no dispute.
My lord.
All right. Then what is the problem? These are appointments on contractual basis or regular?
No,
Regular.
regular basis, that too in the ICU.
I see, regular basis, my lord, all along. And these posts were created on regular basis.
But
If my lord can have page 58 for a second,
Yes.
that's the select list. The last paragraph, my lord.
Yes.
Out of the 68 vacant posts which were advertised, my lord, in different categories advertised, only 22 posts could be filled up and the rest 44 could not be filled up due to non-availability of eligible and suitable candidates.
Yes.
So my lord, everything was gone into, and then only out of that list, 22 was found. Then again, 47 posts were advertised, my lord,
Right.
without my lord touching this. So this was my lord continuing. They were to appoint, but that was not done, my lord. In the meantime, we had to come up before this honorable court because that 1 year period was lapsing.
The select list, the life of the select list is 1 year only.
1 year,
Yes.
but between that, I had come up before your
You have
lordship.
come up.
Before the, my lord, last month, my lord.
Last month, I had come up before your lordship.
Okay. Now what they are proposing to fill in the post by clubbing them with the future
My
vacancies.
lord, they had already done that. That decision was of September, my lord.
Mhm.
In December, they advertised those posts, but only 47.
Yes.
Only 47.
Only 47.
So your candidates are how many in number?
Mine in the writ appeal 14. Writ appeal
14 only.
14 only.
Okay. So what
Well, in
the
the
others have got, got
Lordship,
others may have got,
3 have got, my lord, from the writ petition, at least 3 have got now.
Yes.
okay. Now, supposing now we issue the direction, their appointments will be prospective,
It has to be prospective.
obviously.
It has to be
They
prospective.
don't have any crystallized right
No,
as such.
no.
All right. What do you
Only,
say?
my lord, one thing, my lord, that skill test would not be held at that point of time.
So
because
we will make it clear, subject to clearing the
Yes,
skill
ma'am.
test.
That part may be indicated, my lord.
Yeah, they have to do that.
Not-
Where is the prescription of skill test?
It's not there.
But it's otherwise not there, but that it was.
In the rules, give us out from the rules required.
No rule.
I see, my lord, that rules.
Is there any prescription? So where do you say so from?
And it was, my lord, the mode of selection, they thought that they will.
They are qualified. Your mode of selection is otherwise written test. What is the mode?
It was my walk-in interview.
What, otherwise, what is the mode?
Otherwise, my
In
lord,
regular
it-
process.
thereafter skill test.
So let's see that now. Where are the rules?
My lord, that rules, my lord, there is no service rules for this particular post.
There is no
Technician-
service rule at all.
No.
No.
Then how do you
I
make
see-
the selections?
My lord, the selection
routine.
board, they adopt a particular procedure, my lord, to conduct that.
Now,
selection.
you, wait, tell us, gentlemen, the last process you held,
Yes, ma'am.
how was that done?
Yeah, for that 47 post, my lord.
Yes.
Mhm.
Well, it was a written and skill test as per the advertisement,
Yes.
as per the affidavit.
So we can qualify this appointment saying that skill test will have to
We'll
be.
do that. no?
Yes, ma'am.
I'm-
Skill
I'm-
test
we
only,
will-
my
we
lord,
will
that is the hurdle, my lord. If
We
they
will
qualify in the
subject
skill-
ourselves to that.
All right. Skill test because let their proficiency at least.
Lordship,
test.
I have no objection on that. But it should be a time bound manner.
Yes, of course. 2 months.
Lordship.
My lord.
So this affidavit you have filed,
My lord, I've given a copy, my lord.
200
Yesterday we have filed this.
200
Filed by
people.
respondent number 1 and 2.
203 on this.
let's see what they have said about the list.
My lord.
Page 207. madam.
Yes, yes. However, as per records, there is no government order
Cancel-
cancelling the select list.
Yes.
dated.
Only thing, my lord, they have stated is that, my lord, the select list as of now has lost its validity. But, my lord, it's a.
There was a litigation going on.
Yes.
They had approached the court. Okay,
Much obliged.
we'll dispose it of. Give us a brief synopsis, Mr. Nair.
Lordship. Lordship. Well, can I give it by tomorrow morning? madam?
We want to dispose it of today.
Today is tomorrow.
Yes.
I'll give it. When I do tomorrow.
Now let them list for pronouncement of order tomorrow
Lordship.
or on 19th. Let it come on tomorrow. evening. Give us during the course of the day.
Lordship, I'll do that.
Item number 17 to 19.
Yes.
The day is for compliance report, let's say.
We have given the admission, lordship,
Given-
as per the direction of this honorable court.
Let the order be brought on record.
Lordship, then let us file an affidavit. Tomorrow we'll file the affidavit.
You can just show us the order.
Yes, Lord.
We'll give it till tomorrow. No issue, no issues.
Lordship.
Because even in that interim relief order, we have said that verification will be necessary.
Your lordship,
So that's all right.
that process we have initiated,
We
lordship.
also gave our undertaking. We also gave our undertaking.
Given, obviously, otherwise you wouldn't have been admitted.
Yes, that's.
All right. Three candidates.
Rani Nayak, Smita and.
Kumari and
Saildeep.
Saildeep. Land Advocate General submits that the appellants herein have been admitted pursuant to the direction given by this court in compliance to the order dated 11/10/2023 passed by this court. He shall bring the relevant order on record order/communication on record with an affidavit, list tomorrow. We'll dispose of the appeals.
Day after tomorrow, Lordship. We'll file it.
Day after tomorrow will be the last day, Mr.
Other matters were fixed at top of the list tomorrow.
Tomorrow.
Yeah, the day after tomorrow. Tomorrow I am not available. Otherwise, if my absence is not.
No,
required,
no,
that Lordship.
you be here.
Lord.
We need your assistance.
Lordship.
But now we can dispose of on these terms?
Yes, Lordship.
Yes.
Connecting cases are coming day after tomorrow.
Okay.
My lord, item number 31 is the same, my lord, subject, my lord. Or maybe taken up, my lord, that.
31.
Yes, ma'am.
Let it be called off.
Yes, ma'am, sure.
Now-
Please, Your Lordship. Your Lordship, I am appearing for respondent number 10, Your Lordship, in the writ appeal, Your Lordship.
Which one?
Item number 19, Your Lordship.
Yes.
Yes, Your Lordship. I have been included as a respondent number 10, Your Lordship. And I have, though I have no merit in the MBBS.
My lord, her name was.
Oh, no, we know that on the last date also
Yes, Your Lordship.
we'll make it clear. You did not, your candidate client did not stand in merit.
Yes, Your
So
Lordship.
no adversities coming your way in
Yes,
this
Your
appeal.
Lordship. But I have been denied to take admission in the BDS course. Your Lordship.
For that, you have to file your own writ petition.
Your Lordship.
Your own writ petition, you have to process.
My lord.
Yes. Yeah. Tomorrow.
Item number 20.
No, this is a third party appeal, my lord. We have filed leave petition. Accordingly, leave petition has been granted today.
You have filed?
Leave petition that has been granted, my lord. My lord, this matter relates to selection and appointment to the post of LDA in Sohit Mukut Onil Bora Memorial High School, Nagaon district, my lord. I participated along with other candidates, and thereafter the select list was results were published. Then it appears that there are some anomalies, and accordingly public complaints was lost. I also approached this honorable court, page 28. This
You approach this court.
yes, my lord.
What has happened in your?
Yes, my lord. At that time, my lord.
Let's get the order. Yes, 29.
Yes, my lord. Page 27, then 20, then 31 is the operative part.
You approach the court.
Yes, my lord. Since there was some anomalies.
No, 28 is a writ petition by Arifuddin.
Arifuddin and second writ petition.
Okay. Niranjan. Okay.
Arifuddin is a private respondent. He has also approached for his appointment. We have approached for re-verification of select list.
Okay.
At that time, select list was not approved. Therefore, my matter was declared to be premature. However, liberty was granted to approach this honorable court, approach the concerned authorities by filing representation. I filed a representation. Thereafter, page 32, the inspector of school.
Yes.
After here, all the parties, the examiner, the headmaster, school selection committee, he found that there are some anomalies, and accordingly, page 34, this is the operative portion. Under the factions stated above, I am of the considered.
Yes, select list is vitiated, cannot be considered.
Yes, my lord.
Then what happened?
Then, my lord, at page 35, I filed representation for reinitiation of the selection process.
Yes.
Then private respondent, without making us party, the private respondent has approved this honorable court, page 36 onwards. Then paragraph 11 and 12, he has made a statement that the headmaster as well as the inspector of school instigated some of the candidates to file complaint against him.
Yes.
But in the same writ petition, he has made contradictory statement in page 55, paragraph 27, stating that the headmaster of the school very sincerely done the re-scrutinize. After re-scrutinize, he has been given 12 mark extra. As it is, he has been selected. Without informing the selection committee, he has been selected, my lord. Thereafter.
What does the learned single judge say about your non-impleadment?
My lord, we could not place our statement, my lord.
But you have been granted leave to file an appeal.
In this case, my lord.
Yes.
Yes, my lord.
Where is the leave order?
My lord, leave order on 13, that is on 11/10/2023, IA number 3130, connected IA. My lord, the learned single judge has passed this order without verifying the records. Though the learned single judge earlier directed the standing council to produce the.
No, let's issue notice. Order on a prayer for interim relief. In the meantime, comma, there shall be a stay on the impugned judgment of so and so. Dated so and so.
Highly object.
Steps for service be taken in 7 days without process be issued.
My lord, I have only one bona fide mistake, my lord. In our appeal memo, the prayer portion has been somehow is missing, my lord.
Prayer portion is not there.
No, my lord, I have annexed, but it was somehow not annexed. Today I will annex, my lord.
So let you rectify that error first, then we'll pass the order. Without that, how can it be?
My lord, page 15, then in view of above, the judgment and order shall be bad in law and as such the liable to be set aside was.
Yes.
But
Then-
here of the certificate is annexed. This is my mistake, my lord. So today.
No, the relief sought for page 16 is there. That page, somehow or the other you have managed to insert.
Oh, then yes.
There are 2 page 16 marks.
Oh, yes, my lord.
Okay.
my lord.
Stay.
Highly object.
We'll note some facts. Transcribe the order and then point it out. I'll note some facts.
Item 21.
Yes, Mr. Ganguly.
What has happened on the last date is that we indeed took possession of both the properties. But as far as the Schedule A property, my lord, my learned friend made a submission that they have cooperated in that. That was not the case. What has happened, my lord, is that there is an error, my lord, in the boundary on one side, maybe. And as a result of that error, which was only discovered during the time of physical position and inspection by the Lat Mandal, my lord, the auction purchaser has now expressed his unwillingness to continue with the sale.
Well,
So
that
we-
is your problem.
we
You
will
had,
have to-
you had before keeping the properties mortgage,
Yeah.
you were supposed to do a physical inspection.
They
My
had
lord,
done what?
actually,
We had already
So,
given all the
my lord,
documents. Lord.
Can he, my lord, taken advantage of his own right? This mortgage was created by them, my lord.
But he's wrong. You are equally true, equally.
We
at
accept
fault.
that.
Then-
We accept that, my lord.
Then
As a result, my lord, my instruction is that the sale certificate will be withdrawn, my lord.
will be withdrawn means what?
Yes.
Let it be withdrawn thereafter only.
Yes, my
Well,
lord,
if you-
we are
if
in the
the
process,
Property number 1
lordship.
covers more than your overdues,
Lordship.
then how can you go for the property?
Now the property number 1, the Schedule A property, my lord, will have to be revalued. There will have to be a fresh valuation, a fresh auction,
So let
and
them-
there are.
So why jump to conclusions? They can't sell the property B.
They can't sell the property.
Then why you take possession thereof?
No, the Schedule A.
Complete the proceeding for Schedule A.
Lordship.
If that doesn't cover your overdues, then only you are
At
required to.
present, my lord, the bar on the Schedule B property, my lord, that may be removed because, my lord, there is nothing in law which forces me to, my lord, sell one property in view of the other.
You had gone for the sale of one property.
Only one property, my lord,
Then-
that has to be cancelled now. my lord.
So
No, he can't
those
have his
facts,
cake and eat it
those
also.
facts are not on record, sir.
No, that's because. it's a-
All your oral statement.
My lord, what has transpired after this petition has been filed.
So all right, you come out with the affidavit,
I'll
and
come
then
out
the
with the
stay will continue.
My lord, immediately on the reopening, my lord, I'll
Yes,
file my-
Ms. Ganguly, appearing for the respondent bank, submits that the though the Schedule A property has been sold, but owing to some discrepancies in the description of the boundaries thereof, the sale purchaser is backing out from the offer to purchase the property. He prays for and is granted 2 weeks time to bring the relevant facts on record.
Lordship,
Interim order
If I may say, Lordship, please have a look at page 67, Lordship.
57.
67, Lordship. It's the
Yes.
valuation report of the Schedule A property.
Hmm.
Here, Lordship, the value of the land itself is more than
4 crores.
Yes, Lordship.
My lord,
Yes.
I have
And
instructed, my lord, if he brings a bidder for 4 crores, my lord, we are ready to give it back. There's no
Okay,
question.
let them.
No, they can't. This is
My
not a
Lordship, my
contract.
You
humble,
bring a bidder of
Yes,
4
no,
crores.
Let him bring.
You
the
buy it
4
for 4 crores, all right.
Lordship,
We
my,
give you the liberty. You buy it for 4 crores. Okay,
I don't have that kind of money.
then this
Lordship,
is all,
Lordship, my humble prayer is that.
this is
let
an
the-
all an eyewash.
Lordship, my humble prayer is that let auction, Schedule A property be auction first. If
No,
the
that is
auction-
not your choice.
That
That is not your choice.
Lordship,
If this practice brought on record, your stay will go. Then they can go for either of the properties. That's their choice, either or both even. Interim order shall continue till next date, list on 7th November. Public.
Item number 22.
May I please, Lordship? Okay, matter pertaining to non-payment of the, my lord, the pension benefit on last occasion, Lordship directed.
Non-payment of
Pension benefit, my lord, the.
pensionary benefits.
Now,
okay.
Kindly see the last order passed by
Hmm.
this honorable court.
CEO Golpada. Yes.
Yes, Lord.
My lord, they are appearing, but I just have to give the background manner. In this case, the writ petition was filed praying for area accumulated pension and salary also.
Pension and other.
Pension and other retirement benefits. He also prayed for current pension.
Hmm.
But Honorable Single Judge disposed of the writ petition directing only the payment of area pension. Lordship will permit me.
Very,
There
very
is a
simple
reason.
statement.
There is a reason
Yes.
I'll just.
Yes.
The Honorable Single Judge simply directed that pay the area pension. In course of the proceeding, there was a bargain sort of thing, my lord, that how much, what installment you will pay.
Hmm.
The Honorable Court, we offered 20,000, the Honorable Court said, no, you have to pay 25,000 per quarter.
Hmm.
That we are paying. Now, they did
What is his actual entitlement
13
per month?
13 lakhs
Per month pension. Monthly
Per-
pension, what is his monthly pension?
per month pension.
Yes.
It was an agreed order, my lord. So far as the installment is concerned, the amount of installment,
Right now, Mr. Mazumdar, we have called them for the reason
my lord,
that you are not paying the current
my
pension.
lord, I have to make my submission on that.
Yes.
Unfortunately, my lord, unlike other state government employees and other municipal boards throughout Assam,
Mm.
they are getting pension like we had under the 1969 rules.
Yes.
From 2005 onwards, even the state government is getting NPS, that is new defined pension
Those
scheme.
employees who came in service up to 2005, not
Yes,
the existing set of employees.
yes, my lord.
When was this appellant employed? What is his date of appointment in the Golpada municipality?
No, so far as this person is concerned, my lord, whatever is due, they are ready to pay. They are not challenging that. I am only on the question as to whether, my lord, he is entitled to full pension after the new defined pension is come or not. That your lordship will adjudicate. My lord, I have to make my submission because there are already 2 resolutions to revisit the entire scheme because we are unable to pay. They don't have fund.
Take the resolution, thereafter they will have a right to challenge.
About the pension, my lord, the act itself says it will be either gratuity or pension. Now somehow the calculation is made beyond the act. They are taking.
Mr. Mazumdar, if your argument were to be accepted,
My lord.
he can't even claim areas of pension.
What I'm saying is, my lord, if the act says you will get either gratuity or pension, lordship will decide, my lord. If your lordship decides no, he will get both, we'll pay.
Mr.
So,
Mazumdar,
we are
we are
concerned-
posing you a simple query.
My lord,
If your argument were to be accepted,
my lord.
whether he would be entitled to claim even pension arrears. Arrears started accumulating from which year? Tell us.
From which year?
You are not instructed, Mr. Mazumdar, unfortunately.
No,
You are not instructed.
It is there on record, my
All right, tell us the date.
lord.
So as per what you are saying,
My lord.
2005 onwards, he is not entitled to any pension. That's right.
No, my lord. If he's a person employed prior to that, as your lordship said, he will get. One minute, we are more because we are more on the question as to whether subsequently appointed person should also get or not. Because
He is not a subsequently appointed person.
my lord, about him, my lord. Although your lordship has directed their personal affairs, my submission before lordship is.
We'll
like
attach
this.
their salaries.
My lord,
We'll attach their salaries.
No, madam,
Pay him pension.
my lord, provided if they do not want to pay, your lordship will pass the kind of order. They do not have any intention of not complying with the court's order. My lord,
Mr.
I asked
Mazumdar,
them-
you have already been given a leeway
my lord,
of paying the pension in pittance. What is 25,000 rupees in 4 months?
That is-
Nothing.
my lord, that
It's
they have-
nothing, Mr. Mazumdar, 8,000 rupees a month, less than that.
my lord, once your lordship modifies that order, we'll pay in terms of the modified order also. We have my submission before lordship, they have complied with the order passed by the Honorable Single
We are
Judge.
presently not interfering in that order,
My lord,
but what about the current pension?
but that also they will pay.
So then let them
My
pay.
lord, I only want that, my lord, writ appeal itself has been filed claiming the current pension.
Yes.
Now, current pension, whether your lordship will direct them to pay the pension in terms of what he's claiming, or
under the law what he is entitled. That for that adjudication, my lord, the writ appeal is
Alright,
yet to be.
let's adjudicate right now.
My lord, my lord,
Proceed.
my lord,
Why he is not entitled to pension? Tell us.
my lord.
On what premise do you raise this argument?
My lord, first of all, my lord, writ petition, in the writ petition, my lord, they have, my lord, I have to, I'm just, at the cost of repetition, I'm submitting. They have agreed for an order of clearance of arrear pension first, and we are paying that. We have,
So
in
does
fact, we
it
have
mean
paid
that
in
he has
advance.
foregone the right to claim current pension?
Not at all, my lord. What I'm saying is, my lord, they have filed the writ appeal, lordship will adjudicate.
Your
Lordship will
order,
decide.
Mr. Mazumdar,
My lord,
your argument is counterproductive. Once you agree to arrear pensions,
my lord.
can you challenge the entitlement for pension? We don't understand what is the argument coming from you.
I'm only on the two things, my lord. Only on one is on rate. And secondly, my lord, they want us observation from your lordship that there are already resolutions where we have indicated that we will revisit the entire scheme. Those
Oh, you do
observations
that.
we want from your lordship, my lord.
When
Because my lord, why
that
I'm saying, my lord,
revisitation comes around,
my lord, why
then only you can modify,
lordship will
not
just-
before
my
that.
lord, lordship will just be the whole purpose of placing all these things is, my lord. The whole claim is based on an earlier order passed when this new defined pension scheme didn't come. Others
You
were
are
also
seeing
claiming.
that you have not prepared the matter, sorry. The new pension scheme is applicable to employees who come into service after that particular date in 2005.
Yes.
He is not that employee. Can it be retrospectively applied?
No, so far, my lord, that is why I say, my lord. Earlier, based on order passed at the instance of the association, my lord, union, everybody is claiming. Even
They will claim, they will claim definitely.
even for persons who were appointed 2000 after 2005 also. they may
Mazumdar,
claim.
the simple test is after 2005 that is dispute is going on presently.
My lord,
The issue is
my lord,
that NPS
will apply.
contemplates deduction of a certain portion from the salary and equal contribution by the employer.
Exactly.
That was never done in his case
No.
because he was being given pension.
Right.
So where is the question of NPS being
That
applied?
is why I say, my lord, so far as he is concerned, we are ready to pay. I'm not
So
saying
pay.
for a moment.
That's what he's asking for.
My lord, we'll pay. We'll pay. My lord, since there was so far as the till now the payment is concerned, my lord, they have complied with the order passed by honorable judge. They have been paying. In fact, they have paid in advance, my lord. I'm told that we have paid in advance. And the
Mazumdar,
current pension also they will
we
pay.
have got a lot of time today.
My lord,
A lot of time to spare.
current pension
Let's-
also they will pay, my lord.
All right.
That's what they are
Let's go on for a storytelling time.
saying. No, and they will
Doing this simple order, current pension, what is your stand?
current pension they have to pay, my lord.
Then all right, what was this argument coming from?
Because, my lord, because there is a reason, my lord. Because, my lord, already there are resolutions that we will change it. We want an observation because based on this.
No, we will not make any observation
My lord.
based on the hits made in thin air.
Others.
They will change it. Let them change it.
My lord.
That's a policy decision.
My lord.
If it comes around, the employees will have to take their own grievance redressal
Yes,
mechanism.
yes.
But till then, you can't deny it. So now what do you want us to do? Attach their salary and pay the pension?
No pension, my lord, that's why I say they are ready to pay.
All right, deposited in his account. How much is due after the?
But one submission they have to make, my lord.
Yes.
Present financial position is such, they are paying to one person, they are paying less to another person. This is how they are managing because their fund is not. So that's
right.
relief they will give, the lords will give.
Mr. Mazumdar,
My lord.
in this autonomous system of functioning
My lord.
created by the constitutional amendment,
My lord.
the local bodies have to manage their affairs.
Yes.
Otherwise,
And-
the government
and
has to support.
My lord, lordship is also aware of the judgments where it says that if the municipality is not in a position to pay, not
The government has to give bailout packages. That's the only answer.
government.
We have done that in Rajasthan State Road Transport Corporation.
Yes.
The government was requested, they made payment of 500 crores only for pension
Pension.
and salary even. What can be done?
Lordship will give
That's a
them,
liability you have incurred.
lordship will give them some time. They will give. This
How much
only-
time? You make a statement.
Correct.
Current pension is due from which month?
Correct.
With somebody,
My lord, current pay
Maybe from
2018, my lord.
Hmm?
Last calculated pension amount that we have placed 2018, my lord.
No, possibly-
thereafter, no, not a single payment.
no, my lord.
What outstanding amount that they are paying, my lord, that
Possibly
is
they
up
do
to 2018. Therefore,
Okay.
they are totally.
They will be able to pay from November.
From earlier period here.
Ms. Mazumdar,
No, no, I'm
you
just
have a
finding.
discussion with the officers, come back after 5.
Yes, yes. I'll.
Talk to you.
Just 5 minutes.
Yes, yes, sure.
Item 23.
May I please is your lordship? Your lordship, here instruction is awaited, your lordship. We need to file our affidavit.
And council MS submits that still complete instructions have not been received and more time is required to file reply. Affidavit in opposition.
That government now trying to fill up the state post, my lord, principal, my lord. And
Post
I have
of-
challenged the rule, my lord, regarding
What is the post on which?
post of principal, my lord.
Principal
area-
advisor.
Principal,
My lord.
okay. Is there any advertisement?
My lord, there is a communication, my lord. For
Let's see. You have challenged the rules. On what ground?
Rule 12, my lord. And 13.
What is the ground for challenge?
Challenge, my lord, the petitioners are the, my lord, are the assistant teacher of LP schools, my lord, and subsequently in the year 2016, my lord, as per my lord amalgamation scheme, 6 scheme, my lord, they were amalgamated with the higher secondary schools, my lord. But in the 18 rules, my lord, there is no provision for, my lord, eligibility for.
All right, we'll make an observation that the appointments made, if any, will remain subject to the outcome of it. Space for further time to file affidavit. We may note that this writ petition is pending since the year 2022. The petitioner's counsel has expressed an apprehension based on a communication dated 11/9/23 that the posts for principal for higher secondary schools on which, the petitioners stake a claim may be filled up in the meantime. First up, considering the facts and circumstances noted above, it is hereby directed that appointments, if any, made to the post of principal in the intervening during pendency of this writ petition shall remain subject to outcome thereof. List after 3 weeks. We make it clear that no further time shall be granted to the respondents for filing affidavit in opposition in this matter.
My lord.
Deeply obliged.
Item 24.
Well, this case will be led by senior counsel Mr. Ken Chaudhary, lordship. So kindly pass over the line being lordship.
Also,
Public.
Item 27.
In this case, I have filed my pleadings, my lord. The petitioner's claim was rejected, my lord. Initially, the petitioner had applied for grade 4, but it was rejected on grade 3. They have filed an affidavit, my lord, stating that I have applied for grade 3, but initially my application was for grade 4, my lord. And
your application,
my application which I had filed, my lord.
this is on compassionate grounds.
Yes, my lord.
All right. Let's
Then, my
see.
lord, my application is a page, my lord. 77, my lord.
Yes.
And my father was working as a grade 4 staff, my lord. That is,
Then what happened to your application?
it was rejected, my lord, by the DLC had forwarded my name, but the SLC had rejected, my lord.
Page.
The rejection is a page, my lord. 105
105.
at serial number 22, my lord.
Just all right. The DLC had forwarded for which post?
DLC for grade 3, my lord.
Okay. Yes.
Then, my lord, I have come across a judgment, my lord, which says that if the deceased parent who was working, if he is working as a grade 4, then the person who has applied, he should also be applied for grade 4 or grade 3 as regards the qualification.
Primarily, the question is that If you had applied for grade 4, why did they reject your application saying that?
My lord.
Hmm.
And there's an order passed by this court, my lord, on 24/7/23, my lord, wherein I have said that I do not want grade 3 post, I want a grade 4 post, my lord.
Well, in fact, my lord, in a compassionate appointment, the person applies for a post, whether it is grade 4 or grade 3, it is for the authority. Here in this case, my lord, I have seen that his case has been, he is a BA pass candidate, my lord, graduate. That is why possibly he was considered as a grade 3. But I have seen, my lord, his case was forwarded by the authority to the GLC as a under grade 3, my lord. And wherever the vacancy is available, the authority has to consider in that, my lord.
You just see 105 does not possess required qualification for SA.
SA.
That is
Section assistant. Section assistant is HS science. This is the minimum qualification.
section assistant is a grade 3 post or grade 4.
It's a grade 3 post.
So all right, he had applied for grade 4. You don't suit him for the reason that he doesn't have the qualification. He has the qualification for grade 4, no dispute.
Otherwise, for the junior assistant post, my lord, BA is required. Lordship, in any case, he has been rejected. He ought to have been considered.
The rejection is illegal, pure, plain and simple.
Lordship.
Yes.
Lordship, kindly see the affidavit filed by the deputy commissioner.
Yes.
Page 135.
Yes, please.
It is clearly mentioned there.
135.
For which employment is proposed, grade 3. This is the application filed by the, my lord, appellant. Accordingly, he was considered. And it was
Just a minute, just a minute. Just come back to page 77, please.
77.
Yes, all right. You have Zila Parishad, Demaji, 135. Come back to 135. What have you mentioned? Shri Santanu Kavar. Who is Santanu Kavar?
Another person.
So another person. Why have you referred his name?
Page number possibly is not correct. It is 135 crore. Go to 135 crore.
Lordship, referring page 135.
Yes, you pointed out 135.
Yes, 135.
So that is Santanu Kavar. Why are we bothered with Santanu?
Then, my lord, resignation may be wrong, my lord. My lord, this is an application 133.
Application by whom?
This is a format. He has to file it, my lord.
Oh, you have not rejected on that ground, sir.
No, because he has applied grade 3 post accordingly.
Where is that application?
That is I am referring, my lord. That is I am referring, my lord. This is, my lord, forwarded by executive engineer, PWD, to the DLC, my lord.
What is the page?
Yes, my lord.
Affidavit by whom?
Affidavit by Deputy Commissioner, my lord. District Commissioner Hamadi.
Can you point out the page number, gentlemen?
The affidavit.
Yes, Ankur Barali.
No.
Yes, that is it.
Yes, this is.
177 onwards.
77.
Already you sent another form.
Wrongly paginated.
But this application at page 77 says that after the death of my father, who was a grade 4 person, that grade 4 post has fallen vacant. So you consider my appointment in that post.
That is the application.
Application at page 77, vernacular is at 78. He said that with the undersigned, pray you to appoint my first son, Sri Debo Kolita, on the compassionate ground to the grade 4 post, which is lying vacant after my husband's father's death.
Yes.
So they have said, it is not that you appoint me under grade 4 post. He said that my father died.
All right, so that is the intention of behind the application.
No,
This format, Mr. Nath. This format is also signed by him.
The format is sent by the executive engineer.
No.
Considering his particular.
Format is signed by him. Page 181, last page.
Yeah.
Just above the executive engineer sign.
Yes.
He has signed it.
Correct.
What do you say, Mr. Counsel?
My thing is, my lord, my initial appointment was, application was for grade 4. my lord, may kindly peruse page 77.
That we have seen, of course, yes.
And moreover, they could not have considered me for grade 3, my lord, because my father was a grade 4 employee, my lord.
No, that's
And
not correct argument.
in
That's
view of
not a correct argument.
In view of, my lord, may kindly peruse the para 10.2 of the judgment which I have just submitted, my lord.
Ms. Nath,
Lordship.
your rejection is on the ground that he was not having a graduation,
Graduate.
but he is a graduate.
HS Science. He's a graduate, my lord, otherwise qualified for grade 3. But the particular post section assistant, the specific qualification is HS Science.
But he never asked for section assistance.
Correct.
He says grade 3.
Grade 3. True.
So simple grade 3 had asked for.
True, my lord, true.
Section assistant is scored out.
Yes, yes.
So then you
Section
have to
assistant-
consider him on again grade
Yes.
3 or as per the first application.
Correct.
We will remand it accordingly.
Lordship.
But that direction will be subject to the condition that vacancy exists in that year
Yes, yes.
for grade 3
True.
or grade 2 or grade 4, whatever.
Grade 3 or grade 4,
Whatever.
whatever is vacancy, wherever vacancy is available as
Yes.
per pre-qualification. Yes, yes.
Relevant point of view.
Lord.
Yes, okay, hello. Yes, but it's a wrong resolution. Yes, or when he filed it. The format, he says, rejection is on the ground, that it doesn't have, that's it in science. So I can't even imagine this section. Okay,
Graduation.
dispose of. Which is the judgment you are citing, Ms. Counsel? Which judgment are you citing?
2022, my lord, 1 SEC, page 30, my lord, relevant para is 10.
Oh, right. All right, we'll write on this also. Yes. First. Why don't you take supplementary first? Yes.
Supplementary list, item 30.
May I please, your lordship. Possibly the applicant here my lord, the impleadment is one of the respondent in the my lord, connected read petition, my lord. The read petitioners in the connected read petition, my lord, they are seeking for the permanent residential certificate. My lord, our objection is, my lord, permanent residential certificate.
Residential
My lord.
certificate.
And a single tribe certificate also, my lord. So our contention is, my lord, they are non-indigenous to the, my lord, the state of the Arunachal Pradesh. So therefore, my lord, my lord,
Okay, where is the read petition, please?
even they have made, my lord, the categorical statement that, my lord, on objections of the, my lord, the students community, my lord, the decision of the state government has been cancelled, my lord. At paragraph, my lord, specifically paragraph.
They are to be implemented first, my lord.
Just a moment, Mr. Purkayas, just one moment.
My lord. Even in their paragraph, my lord, read petition, my lord, paragraph 31, 34, my lord, 40 also, my lord, they have made, my lord, the specific statement that because of the, my lord, this student community, my lord, the state government has taken the decisions to cancel the, my lord, the proposal for granting, my lord, the permanent resident certificate as well as, my lord, residential tribe certificate to this, my lord, the read petition. My lord.
Before we proceed further, you would like to know why this writ has been filed in Guwahati?
My lord.
Because, my lord, there was some, my lord, disturbance taken place, my lord. Because no advocate was, my lord, allowed to appear in that case, and subsequently some.
You could have argued by VC.
Pardon, my lord?
VC facilities available. Let this be an example. Honorable Supreme Court is time and again giving the directions. VC.
No, I understand, my lord. Because,
Yes.
my lord, we made an application, ultimately that application was considered by the then Chief Justice, Honorable Chief.
All right. Okay, so what you want an impleadment today? All right. IA number so and so has been filed by the applicant seeking impleadment. Do you oppose, Mr. Purkayas?
No, my lord.
As a party respondent in the connected writ petition number so and so. Ms. Purkayas and senior counsel appearing for the respondents writ petitioners respondents number so and so writ petitioners does not object to the prayer for impleadment. Hence, the application is allowed. The appellant is impleaded as a party respondent in the writ petition number so and so. Amended cause title be filed within 2 weeks.
Lordship, one small prayer, Lordship. Lordship, this matter has been engaged, the state government has engaged Mr. P.K. Tiwari to appear in this matter. Lordship, in the cause list. Mr.
Senior counsel's names are not supposed to be disclosed.
Senior.
Even the name of Mr. Purkais is wrongly coming. It's not supposed. Senior counsels do not get their names printed in the call list.
Lordship.
They are engaged today, they may not be engaged tomorrow.
Lordship.
If you pay the fees for the particular date of hearing, then only they will come to argue. So there is no question of a permanent engagement unless it is a settlement of a brief, right? Okay.
Item 21.
Don't force us to make things inconvenient for learned senior advocates in Guwahati. Yes.
May it please your lordship, my lord. My lord, here, my lord, this candidate was, my lord, already granted admission. My lord, on, my lord, person to admission list dated 3/9/2023, my lord. My lord, then she was given, after verification of her TGL certificate, my lord, she was given admission on 7/9, my lord.
Okay, let's see the document.
Yes, my lord. Now, my lord, kindly see that first the page 51, my lord, the 3/9 notification by which admission was granted. My lord.
Just a moment. Page 53. Yes. 53.
My lord, 51, my lord.
51.
51. Annex 12, lordship.
Mandira Satnami.
Yes, my
That is at page 50. Okay,
Yes,
51.
that is
Yes,
the initial
right.
selection.
Yes.
And then, my lord, kindly see.
But was it in the category of, all right, this is provisional admission.
Yes, my lord.
Okay.
And admission receipt I have given, my lord.
Yes.
Page 52 and 50. 55.
And the college has also been allotted.
Yes, my lord.
Barpeta.
Fakhruddin Ali Ahmed Medical College and Hospital.
Yes.
My lord, then, my lord, the problem comes with this 19/9/2023 order passed by the learned single judge, my lord. There, the petitioner was not a party.
Okay. Yeah, that we know.
Yes.
Then what is the subsequent last order?
My lord.
Whereby your admission has been cancelled?
Yes.
Where is that order?
My lord, that notification 29. Yes.
Where is that?
29/9/2023, my lord.
29/9. Where is it?
Page 113, my lord.
113.
Yes.
Yes.
My lord, her name should have been 115, my lord. Page 115, serial number 18. She got, my lord, 340. After 341, she should have been there, my lord. Even if
She got 340.
Yes, 340, my lord.
Okay, so after Ruchira Tasa, her
Correct.
name should have been there.
Yes, my lord. And now, my lord, lordship has passed this judgment, my lord, 11/10, my lord.
Yes.
My lord, I pray, my lord, this same benefit she is also entitled. Because she is ready.
Who appeared? You appeared when we passed that stay order, the first stay order, 29/9.
My lord, 29/9.
You were appearing. Was it not your duty to inform the authorities?
My lord, on that very
Yes,
day,
we tell you, you are equally responsible for the mess.
but I
Strongly, we feel like recommending some action against you. Sir, really, you have created this mess. We don't know intentionally or otherwise. Well, was it not your obligation to inform the authorities?
My lord, I informed them, my lord, immediately. It was an unlisted matter, my lord. After the order was passed.
You are
I
present
sent
in
them
the court.
Names, my lord, of the 4 appellants, stating that some order has been passed. So
Some order, we dictated the order in your presence.
I understand, my lord.
We
that-
passed, expressly said we are staying the order.
Yeah.
Was it not your duty to inform them?
My lord, I informed that, my lord, that some order has been passed regarding this 4. I will convey thereafter. But my lord, this number, retable number was, my lord, at that time it was without leave, my lord, the number was not there.
300.
You should have conveyed that the single bench judgment has been stayed. That was the requirement. No, we don't know how far your conscience allows you.
Lots.
You are responsible for so many candidates losing their admission.
My lord,
9 of them, maybe 4 will get in.
4 will get.
One has lost the life.
My lord, one of my client, my lord, she committed suicide, my lord.
We know.
She
She was your client.
She also pursuing in the, my lord, before the learned single judge, my lord. My lord, for a moment, my lord, even if, my lord, assume that the inquiry done at page 81 is
Yes.
correct, my lord. Page 81. my lord.
81, let's see the inquiry because we have not
Yes.
been benefited by the
Yes.
inquiry report so far.
My lord, that inquiry cleared 25 candidates. Third
No.
para, my lord.
Yes.
Page 81.
Hmm.
After careful examination of reports submitted by competent authority, 25 numbers of candidates have been found to be TGL, ex-TGL
Yes.
category. My lord, now kindly see page 130, 1 my lord, 113,
113,
113, my lord.
just a moment.
Huh?
Where is Advocate General?
113, my lord.
Just. Yes,
The director has granted 32 numbers of candidate, 33, my lord, 1 numbers of candidate, my lord, that withheld. My lord, 7 numbers of candidate more, how the director can give, my lord, admission? Even for a moment we assume.
so no, the direction of the single judge was verify of all,
Yes,
verification of all.
my lord.
So the committee has done verification of 25,
No, 25% all verified, 25% they found, my lord.
all in the TGL, ex-TGL.
TGL.
And the admission has been granted up to
32, beyond 25.
My lord,
7 numbers more, how the director can give, my lord?
about more than 100 candidates, they, my lord, applied for this, my lord, under the TGL quota. Out of that, my lord, pursuant to the honorable court's order, my lord, 43 appeared before the screening committee.
and how many were approved?
27 were found.
No,
25,
27.
25.
25. The order is very clear.
No, no. The lordship, so far as this figure is concerned, it is 27. I've checked, my lord. from
Let's see the order. You can't go beyond the order.
My lord.
Read the order, please. Inquiry report.
Yes.
Just hold on.
Yes, my lord. No,
Where is the order?
my lord, we have in fact, my lord, in a affidavit.
So now you go even beyond the report.
No. Lordship, the
Then?
remarks column is there, my lord.
Let's see the remarks
Yes,
column.
my lord. What we will see.
The order by itself conveys very clearly 25. Already, even if it is 27,
Yes.
how 33 were granted admission?
My lord, for that, my lord, those, my lord, 29 lordship has passed the order, my lord, in the writ appeals, my lord.
They were given admission.
They were given admission immediately.
That 32 includes those 4. Are you sure?
Yes.
Let's read the 32. Let's read your 32.
Yes.
Couldn't have been.
It is there, my lord.
All right, read. Revised provisional select list. Let us see the name of the 4 appellants.
Yes.
If that was so, where was the need for passing the order of 11th October? If they had been admitted, where was the requirement of 11-10?
No, my lord, 4, my lord, on 29/9, my lord, 4 appellants, they, my lord, approached the honorable court.
Yes.
They were given, my lord.
Where are those? Let us see.
Yes.
Those are the 4 appellants whose appeals are listed today for compliance.
No, not this, my lord. Tomorrow, those matters are listed tomorrow. Prior to 30th, they came, my lord. P. Mohanto appeared, my lord. The square lordship has stayed that, my lord, cancellation order.
So let us see if they are included in this. Let's see.
Yes, my lord.
Let's see.
So that list has not been annexed, but in the affidavit.
That list is here. 114.
I have the
114 is the list.
130.
Yes.
114.
Yes.
No, my lord, there is a separate list, my lord. I can, my lord, in item number, we have filed on affidavit. It's there, my lord.
Let's see the list. Let's see the list. But
Item 19,
Mr.
my lord, we
Counsel,
have filed an affidavit.
you tell us 32. We are saying from which list?
List dated 29/9, my lord, 113, 114, my lord.
14.
Yes.
Let's read.
Yes.
Who are these candidates?
Yes.
If they are not in that list of verified category, how this list proceeds beyond 25?
Yes. Therefore, my lord, now from my lord, verification list, page 84, lordship kindly see, my lord.
84.
84.
Yes.
Serial number 8, my lord.
Yes, just. We'll probably have to direct an inquiry against your director.
Serial number.
In all probability.
Serial number 8, my lord, page 84.
84.
My lord, now remarks, see, my lord, lordship kindly peruse, my lord. Document establishes that the candidate does not belong to ex-TGL.
That is regarding your appellant.
No, not mine, my lord. This is another candidate, one. Yes,
Page number,
original,
just a minute now. Have your seat. We have now great doubts about your credentials even.
Now, my
Yes,
lord,
Chenny Boyan, document is established, does not belong to ex-TGL. She has been given admission.
My lord. Page
my lord,
104.
now, my lord, 85 page, my lord, 12, serial number 12,
Yes,
T. Boybobi.
yes.
As per the report of the DC Sonitpur, Matka Tea Estate is not in Sonitpur district. Also, NCL certificate provided is cancelled on re-verification and the matter is subject before the Honorable High Court.
No, just we want to know
Yes.
In this very list of 29th,
Yes.
Chenny Buyan has been given admission.
Yes, my lord.
How?
And 12 is also given.
My lord, pursuant to order.
12 is
No, no.
also given.
Chenny Buyan has not been given admission. Documents establish that the candidate does not belong
Given.
to the XTGL.
My lord, given, my lord, in the list, my lord, her name is at the
Yes,
serial number
yes, yes.
Serial number 9, my lord. And T will be, my lord, serial number 13 in the 29.
Call the Advocate General right now. We'll direct an inquiry against your officer.
Lordship,
Right
one
now.
Page one.
Call Advocate General, Mr. Counsel.
My lord. Pursuant to this order. Honorable-
Call the Advocate General right now. Please arrange all the orders in this list in one order,
Yes.
in one sequence,
Yes.
and give out a separate set right now.
Mine.
Yes. Yes, yes, sure. We'll take it up afterwards.
Item 22.
My lord, in this case, my lord, the petitioner was deprived, my lord, by gum sensing process and my lord, my lord, that was.
So we'll have to wait for the outcome of that
My lord,
appeal.
that- apart from that lordship,
Yes.
kindly see page 67 lordship.
67, yes,
Lordship, paragraph 15. May I read,
yes,
lordship?
just.
On perusal of the government instruction referred to by the respondent authorities in their counter affidavit, which has been annexed as annexure number A.
Yes.
It is noticed that it is a letter dated 19/11/2007, written by the Deputy Secretary to the Government of Assam Home Aid Department to the Director General and Inspector General of Police, Assam, Uluwari, by memo number so and so on the subject recruitment of 116 numbers of Sub-Inspector UV approval of the draft advertisement. Thus, it is evident from the aforesaid letter dated 19/11/2007 that the subject matter of the correspondence between the Deputy Secretary to the Government of Assam Home Aid Department and the Director General and Inspector General of Police Assam, Uluwari, is with regard to the recruitment of 116 numbers of
Okay.
Sub-Inspector UV, which is distinct and different from this Sub-Inspector of Police AV. The instant proceeding relates to recruitment of 115 post of Sub-Inspector of Police AV, and therefore the correspondence dated 19/11/2007 stated by the respondent authorities in their counter affidavit to be a letter or government instruction prescribing 25 marks as qualifying marks in the personal interview, which pertains to Sub-Inspector of Police UV, cannot be applied in the.
All right,
My
it
lord.
has been
My lord,
applied for the entire selection process. It's not that one candidate has been
My lord,
isolated.
for the entire settlement, this is the UV, my lord, Inspector UV, lordship.
I
My lord,
understand,
in
but
my
if we were to interfere on this criterion, the entire list would go.
my lord, it is held, my lord, it is held, my lord.
Yes.
It is held that notification is not applicable in case of my lord UV lordship. That is applicable in case of, applicable in
Armed
case of
branch
UV,
and
but
unarmed
not
branch.
AB
Yes.
lordship. We are in
Yes.
AB lordship.
Yes.
My lord, in fact, my lord, as per the findings of this honorable court, learned single judge lordship, there was no criteria, my lord, my lord, specific.
We
kind of
understand,
qualifying
gentlemen, but
lordship.
if we interfere on that ground,
Yes.
the entire process of selection based on interview goes. The selected candidates are not party before us.
My lord, that is why I filed my lord review petition. So the post is vacant lordship, and it is admitted by filing affidavit on 10th post were vacant as on the date of my lord.
The problem is your client did not secure the qualifying marks in interview. That was applied across the board. So would we be required to interfere in that qualification or qualifying criterion of minimum marks while the matter is still pending sub judice for the Honorable
My
Supreme?
lord, there was no qualifying marks lordship. If
They have applied the criterion of UB, all right,
yes,
unarmed branch to the armed branch. But that has been done for all equally. There's no distinction, no discrimination amongst the candidates.
well, EV and AB lordship. It is held by this by the learned single judge.
We understand for the armed branch, this
Yes.
process has been undertaken by applying the yardstick of minimum marks 25 in the interview, right? You are one of the applicants who did not secure that marks. Now, if we interfere on the premise that the standards or a notification applicable to UB cannot be applied to this process,
That is held by this learners.
that entire list goes.
My lord, that is one of the ground of the judgment lordship. Now that part has not been challenged by the my lord state lordship. My lord, in that view lordship, my deprivation was my lord illegal. Apart from the Monzastic, my lord, K Monzastic case lordship. And that is my lord. In fact, my lord, I secured my lord fourth position in my lord written test and fifth in my lord Viva was physical test, my lord. In Viva was I was my lord deprived my lord by my lord fixing in the my lord qualifying. Actually, no qualifying marks was fixed, my lord.
That's what
For
we are
every
saying,
lord.
gentlemen. Now you are in appeal. If you were to apply your logic, we will be basing our findings on K Manjushri. K Manjushri, the judgment has been reserved by Supreme Court. Wait for a while, the judgment will come.
My
Then
lord,
things
my
will take
lord,
their own.
a post may be directed to be kept vacant.
All right.
My lord,
We'll direct that those 10 posts, one post from those 10 will not be filled up.
Lordship, may kindly see, this is not a case, my lord, where, my lord.
It's clearly case you have applied criterion of a different selection to this selection. That's finding of the single judge, which you have not challenged.
My lord.
So if K Manjushri is upheld, your process is vitiated.
My lord, I would like to rely the two paragraph of K Manjushri. My lord, this is different from the present case.
All right, rely. Say,
Because,
Ms. Sharma, entire judgment is subject matter of review.
my lord.
So whether we can refer to those two paragraphs.
My lord, already my lord advertisement was issued on 6/10/2023 lordship.
We'll keep direct
Yes,
one
lost,
post.
lost.
All right. This court is informed that the Honorable Supreme Court has kept the judgment reserved. A larger bench constituted to consider the ratio in the judgment of K Manjushri has heard the matters finally and the judgment is reserved. On the previous date of hearing, Ms. Sharma has filed an affidavit wherein, it is clearly stated that 10 posts from the recruitment subject matter of this litigation, 10 posts of sub-inspector AB pertaining to the recruitment subject matter of this litigation remained unfilled. In this background, we hereby defer the consideration of this writ appeal, awaiting the outcome of the larger bench reference supra. However, one post from the aforesaid 10 posts shall be kept vacant and will not be filled.
All right, that will be subject to outcome of the case.
Of course, goes without saying. List after 3 weeks. Tej Prakash Pathak referred Manjushri. Yes.
Passed over meter, item 22.
Ms. Saikia, in that matter, we have asked Learned Counsel to prepare a synopsis. There is something very, very fishy, which we have noticed.
That matter also come up day after tomorrow, I'll address.
Then there'll be no time. We can take this matter tomorrow if you want. These are distinct. There are some very distinct and very disturbing facts. You need to take note of those because probably you will have to tell the state government to take action against some persons.
No difficulty at all.
Small fact, we don't know. Still, we'll verify it.
Yes.
25 were the certificates verified by the committee. Admission has been given to 32.
Regarding
fresh-
this matter, Lordship, I'll have to.
Yes,
I have
you just take the entire set. Ms. Counsel,
My lord.
you prepare a synopsis
Sure.
of what has been argued.
Yes, my lord.
Share it with Learned Advocate General. We'll take up your matter tomorrow.
Lordship, tomorrow I'll be, my colleague will be here, Lordship. V. Gogoi will,
You'll not be able to address through VC also.
because
You tell us the time. We'll fix the matter at the time when it's convenient for you to address the court.
10:30, Lordship.
10:30?
10:30.
10:30.
Lordship.
Okay.
Lordship. I have.
10:30.
For a matter at 2 o'clock.
Whatever time suits you, 10:30, 1,
10:30.
2 o'clock, whatever suits you.
Only thing I have to reach Shillong by 2 o'clock. That's the only.
Whatever suits you. Whatever suits you, but we'll take up the matter by VC. We need your assistance.
Lordship.
We can't leave it for the last day.
Lordship, there's no
Though
difficulty at all.
one seat is vacant, prima facie,
Yes.
on the same logic, she can be given admission.
No
But
difficulty.
there is something beyond.
Otherwise, that seat will go waste, Lordship. We do not
Yes.
want to waste a single.
No, that's why we keep it tomorrow.
Yes.
But there is something very, very fishy, Mr.
Let me go through
You
it.
just
also.
check that.
Yes.
How 32 could be admitted when the verification is only of 25? How your director could admit 32 people?
No, they cannot go beyond 30. TGL.
They have admitted
Unless
32.
this yesterday's lot, the other.
No, that order was that admission list is of 29.
Lordship, I'll find it.
29, there was no,
There was no such.
nothing at all.
Yes, Lordship.
Just check. Or if you say we can take it at 2 today,
Let it come. Let it come.
Yes, yes.
Because I'm in the midst of another hearing.
so let's have it at 2
My lord.
No, tomorrow 10:30.
tomorrow 10th.
No,
All
because
right.
my lord, my lord, she is also my lord, facing my lord, serious mental agony.
Tell us that the court is
I
seized
have
of the
made
matter.
her understood.
Tell her that the court is seized of the matter.
Yes.
Lord,
Obvious.
tomorrow 10:30.
10:30.
Highly obliged.
Item 22.
Well, I've taken the figures.
Yes.
He has retired in 2015
Yes.
and still.
When did he join service, sir?
No, prior to 2005.
So
That I'm not
the
disputing.
2005 issue is no longer there.
My
Okay.
lord,
That confusion is clear.
for a different purpose, I'll come to that man.
Okay.
My lord, till now, he has been paid by way of pension,
Mm.
4,78,318,
Yes. What is the monthly pension?
25,000 and odd.
25,000.
And he's due, so far as pension is concerned, 14,38,479.
That is till 2018.
No,
Then
till today, I have,
till today.
my lord.
Okay.
No, not till
30th.
He has a different story to tell.
I make the position clear.
No, he will make, I'm just give the figures. first.
The
Our instructions till 30th of October, his due is different paper, my lord. He doesn't have that.
Okay, okay.
14,38,479 by way of pension.
Mm.
And with other retirement benefits, it comes to 19,23,663.
Okay.
Now, one information I have to give to your lordship, my lord. 21% have approached this on the court in different, all are pending. I'll suggest, my lord, lordship may take up along with this appeal or others. So far as pension is concerned, if your lordship directs, they will pay from tomorrow.
Current pension. All right. Mr. Mazumdar submits that numerous other employees, retired employees of the Goalpada Municipal Board have approached this court seeking directions similar to what the appellant seeks in this writ appeal.
21%, including the
21%.
Yes.
Including the appellant.
Including appellant.
Our assures
Including.
on instructions from the chief executive chairman and the chairperson and the CEO, Goalpada Municipal Board, present in the court, Mr. Mazumdar and senior counsel assures that the current pension shall be paid to the petitioner from now onwards. Regarding the arrears, the matter will still remain under consideration.
Only amount may kindly mention 25,000 whatever.
Yes,
Current pension
whatever
at the,
correct.
as per entitlement.
Yes.
Okay.
Why I'm saying, my lord, since Act provides gratuity or pension, that your lordship will decide.
You never went for gratuity. Gratuity would apply when you make an equal contribution at the time when the salary is dispersed. Can't be ex post facto.
I'll make my submission.
Yes. That is what,
They will pay.
to our understanding, that is the concept of gratuity.
Obliged.
Okay.
Possible matter 24.
Made Procedural.
Yes, please.
My lord, basically matter pertains to parole, my lord. And
That
the
NDPS.
NDPS.
Okay.
Lordship knows there are two judgments of Rajasthan High Court, one division bench and full bench. Where, my lord, it was said that it has to be under the government. of
Committee
India.
of the Government of India.
Yeah,
Yes.
and not under the Rajasthan rules.
Yes.
In this case, my lord, my parole was declined under the Assam rules. So therefore, they're supposed to consider under the central rules. That's the plan
Yes.
only.
Who is appearing for central government?
As per direction of this honorable court lordship, I have taken instruction from the central government lordship. I have received the instruction lordship. May I-
What is the instruction, gentlemen?
may-
Oh, you share it with the senior counsel. He needs to know what you are projecting. You can say, you can state orally.
Lordship, there
What is the instruction?
As per instruction lordship, prison is a state subject lordship as per entry 4 list 2 of the 7 city lordship.
Special act.
Admission.
There is a division bench judgment of the Rajasthan High Court. It says under the NDPS Act, the state government is functus officio so far as paroles are concerned. So this instruction is not a proper instruction. You need to read, Mr. Chaudhary, if you are having a copy of the Rastan judgment.
Yes,
Please.
that is they themselves as annexed. Oh, no.
Achha, they have given a,
No, no.
they have referred to a gazette
No, no,
notification
no,
of
no, my lord,
17.
No. No, at page 119 of our paper.
Yes. Ms. Chaudhary, there is one gazette notification of 17, which they have annexed, whereby they have delegated the power.
Oh, to the state government.
Yes.
So it is for the state government to apply.
Who is
Not
appearing
under the Assam rules, but under this rule.
under this rule? Yes.
That's the only thing.
Who is appearing for the Presence Department, Home Department.
Yes.
So let you take this notification. Now the state has to consider. We will dispose it of them.
Yes.
All right. Then Central Government Council has placed on record the gazette notification dated 6 December 2017, issued by the Ministry of Home Affairs, as per which, it has been directed as below. But these paroles are for very limited purposes. They are not regular paroles in the sense of the parole rules. That is what. So if you want regular paroles, you will have to challenge the validity of this notification. Then, Government Council, Mr. Sharma, to take instructions from the appropriate authority of the state government regarding steps to be taken in compliance of this notification.
In fact, I'll be covered by the last line, my lord. Such a parole is rendered necessary by reason of any illness.
Yes.
So on ground of illness.
These are all emergent paroles, but regular paroles you will not be.
In fact, my prayer is because my wife is suffering from cancer.
All right. In view of the notification made above, we hereby direct that the competent authority of the state government shall objectively consider and dispose of the pending parole application of the petitioner who has sought emergent parole on the ground of his wife's illness.
Yes.
Okay. The objective decision on the parole application be taken within 30 days from today.
Fine. The
writ petition is disposed of in these terms. Take a copy of this notification.
Yeah,
Okay.
Top of the list matter.
Mr. Chaudhary is no longer engaged. So that's why we were saying the senior's name should not be mentioned.
My lord.
Senior counsel's name should not be there in the call list. That is the reason. You just left the court. Your matter is called out as per the call list. But we don't know you are engaged or not. No, item 4.
Item 4.
Are you sure? No.
My learned friend will appear.
Sir, Mr. Chaudhary, now our observations do merit execution. No? Yes. All right, we'll make it clear now.
But we are in that transitory phase, unlike in Delhi and all these places.
No, Mr. Chaudhary, in Rajasthan, names of senior advocates are not reflected in the call list. It's not required because your engagement,
correct, my lord.
unless it is a settled brief, you're not supposed to appear on every day.
Yes.
Every date. As a matter of fact, we'll be saving you trouble because we have received complaints that senior advocate did not appear on the date fixed. Then there was an engagement or not, one doesn't know. So that perception is created because the name reflects in the call.
Right. And so far as clients are concerned, they hardly know this concept.
That's what. Clients must have paid you a few checks. They think that is a lifelong obligation. Yes.
May please, Lord.
Yes, please.
Well, this appeal has been preferred, with a leave of this honorable court, where in the writ proceedings, I was not made a party. Well, the issue is very simple, my grandfather, so the appellant's grandfather is a dealer, registered dealer of a petrol.
There was some mediation proceeding. Mediation. What happened?
My lord, that is not been, my lord, taken place because he want a different. He said that the other brother, the opposite party.
Mediation failed.
Failed.
Was there actually a mediation or not?
Yes, that opposite party didn't turn up, my lord.
Did
He
not
doesn't want
turn
to-
up.
Yes, he didn't want to, my lord.
You don't want to go for mediation?
Mediation,
It's not correct, my lord. That's not correct. He
Then-
turned up, my lord. It's my personal opinion. He turned up.
But there's a note.
What has happened, my lord? This petrol pump in question is run by Hindu undivided family through a partnership firm, my lord.
Yes.
Now the respondent number 2, whom I am representing, my lord, who was the petitioner, he holds 50% stake, my lord,
Yes.
as per the registered date. And his father expired in the year 2012. Now from 2012 onwards, my lord, the appellants were in their deep slumber, my lord, nobody came forward. The respondent number 2 was running it through his mother, my lord, by executing another partnership date. And in 2019, my lord, a new issue propped up with the IOCL authorities, my lord, which was our basic cause of action for coming before the honorable court to the repetition, my lord. Now, my lord, just before the onset of pandemic, the IOCL issues a letter, my lord, that they have found a will. And in accordance with the will, the reconstitution has been done.
Yes.
Now, it was the case of the repetitioners that their will was never probated. Someone might have.
Is there a requirement of probate in Assam? Rajasthan doesn't require a probate.
My lord, here we probate the will, my lord. For
Are you sure?
lordship, we probate.
Mr. Chaudhary, is the correct position? Okay.
Yeah,
sir.
it has to be provided.
Okay.
Probated. So, my lord, what has happened then? Suddenly they.
It's a registered will.
Not my lord. It was unregistered.
Unregistered. Okay.
And my lord, as per my, I'll check the records, man. But what happened, my lord? Then that issue is settled. Then the other partner, the petitioner, respondent number 2, he placed the reconstitution proposal, my lord. Without considering that, the oil supply was stopped.
Okay.
An order was passed to put the petrol pump in a holiday scheme, which means it goes to a third party. Now, if third party runs the business, goes out of the family, we approach this honorable court. And then again, there was an order for dismantling the outlet.
Okay.
Then the honorable court interferes, gives us some interim protection. Matter proceeded, hearings were held, and the records were produced. In the records, it is true that some complaints were found by some families, and it was argued by us that those complaints have become time barred, my lord, because the Lakshmi Narayan Jalan, who was the father of the appellant and the respondent number 2, he expired way back on 2012, my lord. Now, if any civil right accrues upon the other family members, then they ought to have approached the civil court within a period of 3 years' time, which they did not do. Now, that is why, my lord, the learned single judge in the judgment has decided that whatever the position may be, since this petrol pump has never defaulted in any of its commitments to the IOCL, in the interest of justice, instead of bringing unreasonable restriction in freedom of trade and commerce, let the business continue as it is, and reconstitution may be done as per the proposal submitted. And if anybody feels that they have some right, some accrued right, they can approach the civil
court. Right.
That is the only judgment of the, that is my duty before your lordship today to defend that judgment, my lord.
Yes.
My lord, my prayer is very limited. My lord. What my learned friend is saying, my lord, is not. Still now, the dealership is in the name of MP Jalan. MP Jalan is no more. He died in the year 1980s.
Yes.
Still now, the dealership in his name. Now, the IOC.
That is a firm, not the name of a person.
Person, my lord. Person, my lord, I can show, my lord, not firm, my lord. Firm is.
There has never been any reconstitution.
No, my lord. That's what I am saying, my lord. You kindly see, this is still.
If
now,
we
this
see
is
the respondent number 1.
Okay. Latest, your lordship, kindly see.
But why were you granted leave to file an appeal? You are not a party in the red
Yes,
petition.
they have not made a party.
But
I don't know why they have not made a party.
Were you a part of the IOC, this outlet? Were you a part of that LOI?
We are the legal heirs. There is undisputed that we are legal heirs. Just late Mohabir Prasad Jalan.
Let's see the original LOI. Where's the original LOI? You may have produced one tax invoice. That doesn't help you.
My lord, that is a tax invoice. Still now, this is a tax invoice.
But let us see the LOI to whom the allotment was made. If it is to a firm, then the things become very different. They assume a different character.
Page 70, original allocation, my lord.
Yes.
Page 70.
Original allocation was done in the page 28, my lord, of the petition. I'll just of the writ appeal, my lord. It has to be numbered as. Yes, lordship. Original allocation was done in favor of a
proprietorship fund, my lord.
Where is that?
Page 85, my lord.
85. Even
85.
income tax clearance certificate at 112 says MP Jalan and Sons. There are 3 partners
My lord,
with the firm.
if I may submit, my lord.
But thereafter,
In
page 85.
1969, it is a fact that it was allocated to MP Jalan with
Oh.
the grandfather.
Okay.
Subsequently, in 1972, MP Jalan was converted to a partnership.
Partnership firm.
And in those days, lordship, these rigors of my lord having registered were not much applicable.
Yes.
So,
So did the IOCL accept that reconstitution proposal ever in the name of MP Jalan firm?
that is the difficulty, my lord. What happened? This query was raised by the learned single judge in the proceedings before in the writ petition, my lord.
Okay.
When we apply, my lord, we always apply. I can show from the affidavits
As-
that is digitalized
As a firm.
as a firm,
Okay.
but they accept it as a proprietorship, my lord.
The
In their
company.
system, my lord.
Okay.
But so far as our burden is there to apply, my lord, we have all along been applying as a registered firm, my lord. And the last legal position, if I may say legal position, is MP Jalan became a registered partnership firm, my lord, with the respondent number 2 and his father as the partners, my lord.
Okay.
My lord, and that was the last legal position with a registered deed, my lord, and the firm was also registered, my lord.
Okay.
My lord,
And these documents were uploaded, my lord, in their website, my lord. And,
And what is the stand of the company?
my lord, Lakshmi Narayan
Just
Jalan.
hold on, please.
My lord, the requirement under the guidelines is that, my lord, when the proprietor or my lord, any partner dies, it has to be reconstituted. Then, my lord, we have been writing letters for reconstitution. They have given the proposal, and as per the guidelines, the no objection has to be given by all the legal heirs.
All the legal.
So
heirs.
that, my lord, they cannot provide. As a result, my lord, we had to stop supply, but then, my lord, this court interfered. Now the position is, my lord, the fact, undisputed fact is that, my lord, this requires reconstitution. The honorable single judge has also said you reconstitute. So, my lord.
Reconstitution by what measures? What
my
will
lord,
be the procedure?
reconstitution is, my lord, the legal heirs will decide, my lord, who will be the partners or whatever.
And
my
they'll have to
lord.
otherwise file a suit for getting a declaration who's entitled to be a part of the reconstituted partnership.
My lord,
What else?
we go by the, my lord, the guidelines for reconstitution. And that is very clear. If your lordship kindly
Yes,
comes to
please.
the, my lord, the guidelines. Policy guidelines, your lordship will find, my lord, 190. It starts at 181.
181.
181 it starts.
Mm.
The relevant, my lord,
Did they ever file an application for reconstitution?
they did, my lord.
What
They
has
did.
been done?
And my lord, we have returned it back saying that the legal, the other.
Consent of legal heirs is not
Yeah,
there.
they have to, their NFC has to be given. That
All
is
right.
where.
We have the policy. Which clause?
Clause 4, my lord.
Hmm.
In case of death of the sole proprietor, all partners, the reconstitution may be made in favor of the legal heirs, family members with the consent. I am reading clause 4.
Yes, yes, clause 4.
With the consent of the legal heirs, in such case, the induction of outside contracts will also be permitted, maximum share that is there. Then your lordship may come to, my lord, page 192, clause 9 and 10.
Yes.
Clause 9 says, dispute in case of induction of nominee. My lord, there is a dispute within the family.
Yeah, that is right. That's right.
Dispute in case of induction of nominee, legal heir, family members amongst partners. Partners can transfer his or her shareholding in the dealership of legal heir, family members outside, subject to adherence of applicable statutory provisions and the incoming partner meeting the eligibility criteria. However, if there is any dispute with regard to the induction among the surviving existing partners, then in such case, the dispute may be resolved expeditiously by the dealership. In such cases, OMC would
send a notice.
My lord.
Has it been done?
Yes, my lord. We sent a notice, my lord. And
Then what
my lord, when my lord, they submitted the proposal, but then, my lord, we have returned it because, my lord, NOC was not there. Then if your lordship comes to the next para, during the disputed period, the dealership may be operated by the partners, legal heirs, family members, as per share in the existing partner prior to induction of the new partners. OMC may allow operation of such dealership for a period of 6 months.
Yes.
Or as may be decided on case-to-case basis
And if the dispute remains unresolved, then the dealership may be placed under holiday scheme.
That is an inescapable conclusion that it has to go to the holiday scheme.
Yes, my
If they don't resolve.
Yes, my lord, and holiday scheme is not that it goes to third party, my lord. What
They will
we do is
operate-
that, my lord, we give them 6 months to run.
Yes.
During that period, we ask that you resolve the
Resolve
dispute.
issues.
What happens, my lord, in our other cases, we see, my lord, and the moment where one dealership is, my lord, put under holiday scheme, the resolution comes. Then, my lord, after that, my lord, if you cannot resolve it, they get 2 years time.
Okay.
2 years time to resolve, but and during that period, beyond the 6-month period, we'll run with some, my lord, other.
Some other arrangement. Okay. Yes.
So, my lord, I think the best in this fact situation, my lord, your lordship will give them 6 months time to resolve it.
All right. Yes. What do you say?
Because otherwise, my lord.
Otherwise, they will not reconstitute. You lose the alloy, you lose the pump dealership.
In
That's
fact,
the consequence.
I agree to that, my lord, what my learned friend has said.
All right.
Because he is the beneficiary, his last 2 years, my lord, he was running, he is not interested to do this thing.
My lord, that's actually not the correct proposition.
All right. You tell us the correct position.
If I may place honestly the facts.
Definitely.
This subject to what lordship will hold. My lord, this respondent number 2, as per the last registered deed, he holds 50% stakes. Now, once the father expired, he was open to devolution of father's legacy to all the members. But what they are trying to do, they are seeking to enforce upon his 50% stakes.
Whatever they are doing, those issues you have to settle amongst yourself or go to the civil court, get a declaration. That is the only answer.
So that
the oil company will not accept any proposal for reconstitution unless there is a consent.
And my
Yes, they have that leeway. They have that handle. We'll use the pressure.
Once this policy is there, my lord. Now, my lord, may I just one particular clause which may not be of benefit, my lord. Page 191, my lord.
Yes, please.
In fact, this clause was quoted by the petition respondent number 2 while submitting his proposal, my lord.
Yes, and as a matter of fact, we feel that your writ petition should be dismissed only on the ground that you didn't implead them. Why didn't you implead them?
My lord, at that stage, it was not because of the dispute. It was because of some other reasons given by the oil company. my lord.
You can't operate. Now it's more than 11 years since the death of the main partner.
Lordship.
So beyond 6 months, you can't be allowed to operate.
Lordship, it was being operated with mother and son. They had a partnership, my lord. And my lord, may I just take it?
Yes, all right.
Clause 5.
Clause
In
5.
case of death of partners, which is happened here, my lord, the dealership shall be reconstituted with the legal heirs, family members, with the consent of legal heirs of the deceased party. However, if there is no legal heirs or legal heirs have expressed unwillingness.
And they are not expressed unwillingness. They are willing to participate in the business.
That is why
They are rather craving.
my
It's
lord,
not an unwillingness.
my lord,
They are craving to be a part of the business.
belated, my lord.
Yes.
They're very belated.
Belated is, doesn't matter. Belated is on your part. You were supposed to get the consent and file for reconstitution.
That
Otherwise,
was-
they have a right to put you in a holiday scheme and 6 months, if doesn't happen, give it to a third party.
True, my lord, but that was done actually. That was done. The mother and the did also is also.
How many are the legal heirs of Mr. MP Jalan?
My lord,
All legal heirs are entitled
my lord,
equally.
legal heir certificate has already been placed on record. my lord.
Yes, who are these?
I will just.
Page
62 million,
162.
162 million.
Yes, let's see.
163, like my lord, that's the original. 162 is the.
Yes.
copy, my lord.
So there are 6.
6, my.
So all 6 have to come together
My lord,
and file an application for reconstitution. Otherwise, you give up the right to the pump.
my lord, what has happened?
Yes.
The other legal heirs gave their NOC in favor of the mother and the respondent number 2.
Even if one doesn't give, the reconstitution can't happen.
My lord, I may take your lordship to page 164, my lord. If I
Yes.
just 164.
Yes.
There's a declaration, my lord,
Declaration by whom?
signed by all the other family members, my lord.
Yes.
My lord, I, Sri Lakshmi, who is the other partner, maybe along with Rajesh Kumar Jala, have 50% partnership. My lord,
There was no partnership in the eyes of law so far as the OMC is concerned.
lordship, we have no objection, my lord, to surviving Rajesh Kumar Jala carry on business as MP.
So you get a declaration
Lord.
against him. Get a declaration, go to the civil court. But in the meantime, you lose the right to run the pump.
Now,
Simple as that.
my lord, may I, there is a quota of the family, my lord. If the quota runs, my
So
lord,
it is not an HUF property. It's an individually allotted pump.
lordship,
Unfortunately, Mr. MP Chalan, during his lifetime, never took the trouble of reconstituting. He couldn't foresee what might happen in future. So that's the only answer. So how much time do you need? 6 months more, nothing beyond that. Otherwise, the company will be free to take action
correct, your lordship.
as per law. So we'll set aside the impugned judgment and grant you a lifeline of 6 months to carry out whatever formalities are required as per the guidelines. That's the only answers. And if it doesn't happen in 6 months, then the company will be free to take action as per law. Right, Mr. Counsel?
My lord, I agree.
Dispose of.
Item number 5.
What is this matter about?
Lordship, in
Well,
this,
this matter, Lordship, the pleading is complete. My Lordship has on 7/8 fixed the matter for hearing. Yeah.
it's admitted, your lord.
May I? It is admitted for hearing. No? Can it be on 7th or 9th of November after the?
What is the controversy? We'll fix it.
Lordship, we have challenged 3 grounds, lordship. Firstly, the notice of termination, lordship.
Termination of
Termination of my
contract.
contract, your lordship.
Okay.
Lordship, and we allege and we say that, lordship, the termination that was issued to us was never actually communicated as per the contract agreement, or it was never communicated. And moreover, lordship, thereafter, a purported NIT was issued, which was never published in the director of press also. It was never published in the newspaper also.
Okay.
And upon that purported NIT, lordship, contract was awarded to respondent number 6 on 20 of February 2021. And
Okay.
very surprisingly, lordship, on 22nd of February 2021, 1.9 crores has been
Sanctioned.
released.
Released.
to the
All these
respondent
facts
number
are on
6.
record. All these
Yes,
facts
Lord.
are on record.
Yes, lordship.
How does the writ court deal with these facts?
Lordship, the manner, lordship, how the respondents have terminated me and the manner by which the
You see, subsequent part of grant of dealers, the contract. Was that the subject matter of the writ petition? No.
which lordship?
Grant, illegal grant of contract subsequently. What
No,
you are
that-
saying?
No, that is not, sir, we are not arguing, we are
Only your
challenge-
termination you are
main
in.
challenge was the termination, your lordship.
Okay.
Termination was never served upon us, your lordship.
All right.
There, it's a
Let's
extensive
take it
hearing
on
is
the.
required, your lordship.
When do you want, Ms. Nath?
Lordship, there is a little bit early, your lordship. 9th, lordship, a bit problem, your lordship, there is a consideration.
Let it come up on 16th then.
16.
There's jointly paid list on 16th November for hearing. Works have been completed, yes. So it's an empty formality, yes, but work has been completed.
No, lordship, actually, that is a submit, that is submitted by, but the report said, further subsequent report says the work is not yet completed, lordship. There are inquiry reports are there.
Completed way back, more than a year.
But there are
There is an
inquiry
inquiry
reports,
report.
there are subsequent inquiry
Okay.
reports after the appeal is filed.
All right. Thank you.
With due permission of your lordship, reference will be made on the passing away of late Matin Badaruddin Ahmed and late Lakhapati Sarma, advocate and board members of the Guwahati High Court Bar Association. For order of reference, may I call upon Mr. Pran Bora, Senior Vice President, Guwahati High Court Bar Association.
My lord, honorable chief justice. My lord, the honorable judges, this honorable report. Respected seniors, colleagues at the bar and the registry. Today we are gathered here to mourn the demises of late Lakhapati Sarma, advocate who passed away on Sunday, that is on 8/10/2023. And late Mutin Badaruddin Ahmed, who retraced his last on Friday, 6/10/2023. So when the Lakhapati Sarma died, he was about 75 years. And Mutin Ahmed is of 67 years of age. Late Lakhapati Sarma, advocate born on 1st March 1948, he completed his schooling at Zalanga High School, Nalbari in the year 1962. He passed out pre-university from the Nalbari College in the year 1964 and also passed the Provine examination in 1966. Subsequently, he graduated from Pragyotis College under Guwahati University in the year 1968. He also completed the LLB course from the University Law Colleges under the Guwahati University 1972. He was also diploma holder of associate membership of the Institute of Business Management. Late Lakhapati Sarma, advocate, enrolled himself in the Bar Council of Assam, Nagaland, Mizoram, Nagaland, Manipur, Tripura, and Arunachal in the year 1977. Thereafter, he has taken membership of the Guwahati High Court Bar Association on 16/6/1982. Late Lakhapati Sarma, advocate, was sincere, honest, dedicated, punctual, and good friend of all advocates. His helping attitude to the junior advocate will be remembered by all of the members of the association. He associated in various social activities. We have lost an honest member, and his death is a great loss to not only to the Guwahati High Court Bar Association, but also to the legal fraternity. And it will be difficult to fill up the vacuum created by his death. He leaves behind his wife, Srimati Minima Sharma, and two daughters, namely Mrs. Gita Sharma and Mala Sharma, and host near and dear relatives. And late Mutin Badaruddin, advocate, born on 12th February 1956. His schooling from Don Bosco High School, Guwahati. He completed his LLB from Bibora College, Guwahati. Subsequently, he completed his LLB from Nalbari College. Thereafter, he enrolled himself in the Bar Council of Assam, Nagaland, etc. on 6/4/1999. He was taken a membership of the Guwahati High Court Bar Association on 15/9/1999. After that, he started his practice in this honorable court. We have lost an honest members of and his death is a great loss, not only the Guwahati High Court Bar Association, but also the legal fraternity. And it will be difficult to fill up the vacuum created by his death. He leaves behind his wife and his only daughter, 6 brothers, 3 sisters, and a host of near and dear relatives. I, on my behalf and on behalf of the Guwahati High Court Bar Association Guwahati, express heartfelt condolences and pray to the Almighty for eternal peace of the departed soul. May God give strength to the members of the bereaved family to bear the loss.
Mr. Mahim Chandra Deka, President, Guwahati High Court Advocate Association.
Honorable Chief Justice of Guwahati High Court, Honorable other judges, respected Senior Vice President, Guwahati High Court Bar Association, respected Chairman, Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, respected colleagues in the bar, and respected members of the AST. Today, we have assembled here to condole the death of 2 of our esteemed colleagues, late Mutin Badaruddin Ahmed and late Lakhapati Sarma. Late Mutin Badaruddin Ahmed was born on 12th February 1956. He completed his school education from Don Bosco High School, Guwahati, and graduated from BBA College, Guwahati. He passed the LLB degree examination from Nalbari Law College under the Guwahati University. Then he enrolled himself as an advocate from 6 April 1999 and joined the Guwahati High Court Bar Association from 15 September 1999 and practiced in the Honorable High Court. Harry said that he expired on 6 October 2023 at the age of 67 years, living behind his wife and only daughter. Other departed advocate, late Lakshapati Sharma, was born on 1st March 1948 at village Jagua, Nalbari. He completed his school education from there in the year 1962. He passed BA degree examination from Pragyutic College, Guwahati in 1968. He also passed LLB degree examination from University Law College, Guwahati in the year 1972. Then he enrolled himself as an advocate from 9th March 1977. He joined the Guwahati High Court Bar Association on 16 June 1982 and started practicing before this Honorable High Court. He was known as a prominent advocate, and I personally saw him arguing cases before this Honorable High Court while he was the standing counsel of the Guwahati University. Harry said that he expired on 8 October last at the age of 75 years, leaving his wife, Srimati Meera Sharma, and two daughters, Srimati Gita Sharma and Srimati Mala Sharma, who is an advocate. Said demise of two of our esteemed colleagues, late Motin Borderuddin Ahmed and late Lakshapati Sharma, a great loss to legal fraternity and irreparable loss to all the bereaved family members. On my behalf and on behalf of the Guwahati High Court Advocate Association, I convey our heartfelt condolences to all bereaved family members and pray to the Almighty for eternal peace of their departed.
Mr. P.J. Soikia, Vice Chairman of the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim.
Honorable Chief Justice, honorable judges, members of the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, members of the registry, and my esteemed colleagues. We are assembling here to mourn the death of two of our esteemed colleagues and member of the council who untimely died on 6/10/2023 and 8/10/2023 respectively. Late Motin Borderuddin Ahmed, who is popularly known as Motinda, was born on 12/2/1956. He was enrolled under Bar Council of Assam, Nagaland, etc. on 6/4/1999. He joined the bar at Guwahati High Court and since then has been practicing law at this honorable court as well as other subordinate court of Kamrup, both in civil and criminal side. Late Ahmed was actively involved in the historic Assam movement against illegal migrants of the state. He always actively involved himself in socio-cultural development of the society. He was the founder member of the Lasit Nagar Bahagi Utsav. He was also the founder president of Pragati Samaj, an organization set up to carry out various socio-cultural development activities in Guwahati, more particularly in the Lasit Nagar area. He was also actively associated with the development activities of various masjids in Guwahati. Motinda was suffering from a heart ailment for quite some time, and at the time of his death, he was about 67 years of age. He left behind his wife. His only daughter completed her graduation, 6 brothers, 3 sisters, and a host of relatives. Late Lakshapati Sharma was born on 1/3/1948 in the district of Nalbari. After completion of the BA examination in the year 1968, obtained his LLB degree in the year 1972, and thereafter on 1977, he enrolled under the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, and since then continued the profession before this honorable court, as well as subordinate courts, mostly in civil side. He was also standing counsel for various organizations. Late Sharma had suffering high sugar and heart ailment for quite some time. At the time of his death, late Sharma was about 75 years of age and left behind his wife and 2 daughters. The elder daughter is serving as a faculty in the Institute of Hotel Management, Guwahati, and the younger one is a lawyer and an academic in the United Kingdom. As a lawyer, both late Ahmed and Sharma occupied a distinguished place not only in the Guwahati High Court, but also amongst the entire advocate fraternity of the Northeastern region, and their contribution to the legal field will always be remembered. Due to their amiable and affectionate nature, they were very popular among the advocates fraternity and will always remain in our memories. The sad demise of both the legal lieutenants is a great loss to the entire legal fraternity. Words cannot measure the vacuum left upon by their deaths. And on behalf of the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, convey our deepest condolence to their bereaved family and pray for the departed soul. May their soul rest in peace. Thank you.
Mr. NMB Chaudhary, Additional Advocate General, Arunachal Pradesh.
My Lord, Honorable Chief Justice, Honorable Judges of the Guwahati High Court, Member of the Registry, and my esteemed senior colleague and member of the bar. Today we have assembled here to mourn the death of late Lakshapati Sharma and late Motin Badaruddin Ahmed. Late Lakshapati Sharma was born on 1/3/1948 at Nalbari. He passed his matriculation examination from Jagra High School, Nalbari. Thereafter, he completed pre-university examination and BA examination under the Guwahati University. He completed his LLB degree from University Law College under Guwahati University in the year 1972. He used to practice civil law. Mostly he used to do labor cases, particularly for workmen. He has always argued on behalf of poor workmen who belong to the weaker section of the society. And many landmark cases has been argued by him in labor court as well as in the High Court. He expired on 8/10/2023 and left behind his wife Meera Sharma and 2 daughters. Late Motin Badaruddin Ahmed was born on 12/2/1956. He studied in Don Bosco School, Guwahati, graduated from Bibura College, Guwahati, and thereafter he completed law from Nalbari College. He joined the bar on 15/9/1999 and practiced in the Red Code as well as in Criminal Code. He actively took part in Assam movement. He died on 6/10/2023, left behind his wife and 1 daughter. Today, I, on my personal behalf and behalf of the state of Arunachal Pradesh, condole the death of late Lakshapati Sharma and late Motin Badaruddin Ahmed and pray to the Almighty God that the departed soul may rest in peace.
Mr. Anjan Kalita, Additional Advocate General, Mizoram.
My Lord, Honorable Chief Justice of the Guwahati High Court, Honorable other judges of the Guwahati High Court, members and officers of the registry, my seniors and colleagues at the bar. We had assembled here today to mourn the deaths of 2 esteemed members of the Guwahati High Court Bar Association. In the last couple of weeks, we have lost late Motin Badaruddin Ahmed and late Lakshapati Sharma. It is indeed a sad occasion for us that we had to mourn the demise of as many as 2 of our colleagues at the bar. Late Motin Badaruddin Ahmed was born on 12/2/1956 in Guwahati. After completion of his schooling from Don Bosco School in Guwahati, he joined Bibura College, Guwahati. Thereafter, he obtained his LLB degree from Nalbari Law College and joined Guwahati High Court Bar Association on 15/9/1999. He mostly practiced in the Guwahati High Court. He left for heavenly abode on 6/10/2023, leaving behind his wife and the only daughter. Late Lakshapati Sharma was born in the year 1948 in Nalbari district. He had done his matriculation from Jagara High School, Nalbari, and then completed his degree in arts from Pragjyotish College in Guwahati. He completed his LLB from University Law College, Guwahati University in the year 1972. Thereafter, he joined the legal practice in the year 1977 and joined Guwahati High Court Bar Association on 16/6/1982. He practiced mainly in the civil side in the lower judiciary as well as in the Honorable Guwahati High Court. He rated his last on 8/10/2023, leaving behind his wife and two daughters, one of whom, Ms. Mala Sharma, is an advocate. I, on behalf of the state of Mizoram, as well as on my personal behalf, condole the passing away of late Matin Badruddin Ahmed and late Lakshapati Sharma. I pray for the eternal peace of the departed souls and pray for the blessings of the Almighty to the respective families of the deceased to withstand the unbearable loss.
Mrs. T. Crow, Additional Advocate General, Nagaland.
My Lord, Honorable Chief Justice, His Lordship's companion judges of this honorable court, members of the registry, the learned senior advocates, and my dear colleagues of this esteemed bar. Today we gather to pay homage to late Matin Badar Uddin Ahmed, who passed away at the age of 67, and late Lakshapati Sharma, who passed away at the age of 75. Late Matin Badar was born on 12/2/1956. He did his schooling from Don Bosco High School, Guwahati, and degree from B. Barua College, Guwahati. And after completion of his LLB from Naralbari Law College, he was enrolled to this bar in 1996, and he started practicing. Late Matin Badar is survived by his wife and a daughter. Late Lakshapati Sharma was born on 1/3/1948, matriculated from Nalbari, graduated from Guwahati University, and obtained LLB from University Law College, Guwahati University. Late Lakshapati Sharma was enrolled to this esteemed bar on 9/3/1977 and started practicing in 1982. He is survived by his wife and two daughters. We have heard from the earliest speaker who have said so many things about their contribution and what they have done in the legal field. Indeed, their dad had left a vacuum in the legal fraternity. Joining with my predecessor, I, on my personal behalf and on behalf of the government of Nagaland and the people of Nagaland, express my heartfelt condolences and pray that God may grant comfort and strength to the bereaved family to bear the loss. May their souls rest in peace, and may there be comfort in knowing that someone so special will never be forgotten. Thank you.
Mr. Biplab Chakraborty, Central Government Council.
My Lord, Honorable Chief Justice, Honorable Judges, members of the registry, senior members of the bar, and my dearest colleagues. We have assembled here today to mourn the death of two of our esteemed colleagues, late Lakshapati Sharma and late Matin Badruddin Ahmed. Late Lakshapati Sharma joined the enrolled as a member of the bar in the year 1977. He has extensive practice in the field of civil in the original side as well as before the labor and industrial code. Late Sharma will be always remembered for his pleasant, witty smile when we have to interact with him. And at the time of his death, he left behind his wife and two daughters. Late Matin Badruddin Ahmed was enrolled in the year 1999, and he joined the chamber of Honorable Justice Amitabh Roy. He was a practice under him for quite a considerable period of time. A very humble man and a very soft-spoken. We'll certainly miss both of them. At the time of his death, he left behind his wife and only daughter and a host of relatives. I, on my personal capacity and on behalf of the Union of India, convey my deepest condolence and pray to Almighty for the eternal peace of the departed soul.
Mr. Dipankar Nath, Senior Gov Advocate, Assam.
The Honorable Chief Justice of the Honorable Guwahati High Court, other honorable judges, the learned members of the bar, and the members of the registry of the Honorable Court. Today, we gather here with heavy hearts to mourn the loss of two senior members of our bar, late Matin Badruddin Ahmed and late Lakshapati Sharma. In times like this, words often fall short in capturing the depth of our sorrow and the magnitude of the loss we feel. However, it is important that we come together as a community to remember and honor the life of our dear departed. Late Mother Motin Badaruddin Ahmed joined the bar in the year 1999 and he died on 6/10/2023. Late Lakshapati Sarma joined the bar in the year 1982 and he died on 8/10/2023. Late Motin Badaruddin Ahmed and late Lakshapati Sarma were persons of great integrity, compassion, and wisdom. Their presence brought joy and inspiration to all those fortunate enough to have known them. They touched the lives of many, leaving behind a legacy that will continue to inspire generations to come. As we reflect on the life of late Motin Badaruddin Ahmed and late Lakshapati Sarma, let us remember their unwavering commitment to justice and fairness. They dedicated their life to upholding the principles of law and ensuring that justice prevailed. Their tireless effort in the pursuit of truth and righteousness have left an indelible impact on our legal community. Today, as we bid farewell to our dear departed, let us find solace in the memories we shared with them. Though they may no longer with us in person, their spirit will forever live in our hearts and minds. To the family, friends, and loved ones of late Motin Badaruddin Ahmed and late Lakshapati Sarma, I, on my personal behalf and on behalf of the state of Assam, extend our deepest sympathies and our unwavering support during this difficult time. May you find strength and comfort, the memories you shared, and the love that surrounds you. May their soul rest in eternal peace. Thank you.
Now may we have the honor of reference by Honorable the Chief Justice.
My esteemed brother and sister judges on the bench, Mr. Pran Bora, Senior Vice President, Guwahati High Court Bar Association, Mr. Mahim Chandra Deka, President, Guwahati High Court Advocates Association, Mr. PJ Saikia, Vice Chairman of the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh, and Sikkim, Mr. NNB Chaudhary, Additional Advocate General, Arunachal Pradesh, Mr. Anjan Kalita, Additional Advocate General, Mizoram, Mrs. T. Crow, Additional Advocate General, Nagaland, Mr. Biplav Chakravarti, Central Government Council, Mr. Dipankar Nath, Senior Government Advocate, Assam, then Senior Advocates, members of the bar, members of the registry, and judicial officers, family members of the late advocates. Today, we have assembled here to mourn the sad demise of late Sri Mateen Badaruddin Ahmed and late Sri Lakshapati Sharma, learned advocates and members of the Guwahati High Court Bar Association. Late Sri Mateen Badaruddin Ahmed was born on 12th of February 1956 in Guwahati. He did his schooling from the Don Bosco School, Guwahati, and graduation from the B. Barua College, Guwahati. He obtained the LLB degree from the Nalbari Law College. Thereafter, he enrolled himself as an advocate and joined the Guwahati High Court Advocates Association in the year 1999. He remained associated with the Doyen of the Bar, Honorable Justice Amitabh Roy, for a long time while his lordship was practicing in the courts at Guwahati. Sri Mateen Badaruddin Ahmed breathed last on 6th October 2023 at the age of 67 years, leaving behind his wife and a daughter. Late Sri Lakshapati Sharma was born on 1st of March 1948. He completed his graduation from the Pragjyotish College, Guwahati University in the year 1968 and obtained LLB degree from Municipal Law College, Guwahati in the year 1972. He enrolled himself as an advocate in the year 1977 and eventually joined the Guwahati High Court Bar Association in the year 1997. Sri Sharma breathed last on 8/10/23 at the age of 75 years, leaving behind his wife and two daughters. I did not have the good fortune to meet the learned advocates personally or to hear their arguments, but I am told that they were respected by all for their gentle behavior, amiable disposition, and fair submissions in the court. Their contribution in the legal field will continue to inspire the legal fraternity. Their death is a great loss, not only to their family members, but also to the legal fraternity. I and my brother and sister judges on the bench fully associate with the sentiments and feelings expressed by the members of the bar. I, on behalf of my esteemed colleagues on the bench, the members of the registry, and my own behalf, convey heartfelt condolence to the members of their bereaved families and pray the Almighty God to grant eternal peace to the departed souls and to give sufficient strength and fortitude to the members of the families to bear their irreparable loss. as a mark of respect to the departed souls, I request the learned members of the bar and bench to observe a minute's silence.
Time.
The court work on the judicial side will remain suspended for the rest of the day as a mark of respect to the departed souls.